Okay. Looks like they are all in. We're a minute before we're supposed to start. Nope, right on. So again, welcome everybody for joining us today on the Utah chapter of Community Association Institute and the Legislative Action Committee. And it's always great as we're able to report on our efforts during this last legislative session. There's four of us from LAC that'll be presenting today. But as we get started, I just want to express appreciation to all the members of our LAC. If they're not presenting, they don't always get the recognition and appreciation for all the work that they do. So as we move on, go ahead, Stacy. There was multiple bills that were introduced during this legislative session. We're going to focus mainly on House Bill 217 and Senate Bill 201 today, because that's really the meat of the changes that were done this past year. And again, keep in mind, you can go on, Stacy. Keep in mind that these changes that we're talking about, all the amendments to the statute go into effect May 7th. So we're just a few weeks out here. As a general overview, House Bill 217, sponsored by Representative Walter out of St. George. It's a large bill, 52 pages what it's got there. And obviously with that much, it's impacting several different areas in both the Community Association Act and the Community Association Act, and impacts the way HOAs operate, the way they're managed. One of the biggest changes for this year is they're creating a new ombudsman's office specifically for HOAs, for community associations. So we've had the ombudsman for real estate, but now we've got one specific to HOAs, and Bruce will go through that and give us more specifics. That's in the Department of Commerce, and then also the HOA registry with the Department of Commerce. There's a change to that. Production of documents, how we amend the governing documents, rules, different fees that can be charged, and then also green energy issues. You can go on, Stacy. So as you can see, there's a lot of different areas that are touched on. Too many for us to cover in detail during this 1 hour webinar. So what you can do is look for future blog posts on our website, and we've got that there. And so different members of LAC will be writing some of those and touching on these areas that we don't cover, just to give that information. So as going on, we will have Bruce start talking about the ombudsman. As we're going through, if anybody has questions, just please put it in the chat, and then as we have a break in the presentation, we can answer those. So,
okay. Well, thank you, Quinn. Appreciate your leadership here of our committee. So first of all, we're going to talk about this new ombudsman office, and I want to give you some links that will eventually go live. Right now, they're not live because it doesn't go into effect until May. But you can go on to the legislative and the legislative.le.utah.gov, and that's where you can then select code at the very top, Stacy, at the very top, third column is code. And then you can go into code, Utah code, and Constitution. Utah, yep, next one down, click on that one. And there you can go into Utah code by title, chapter, and section. So we'll go back to the slides and I'll take you to the specific section. But it's a new section called 75 within Title 13 of the Department of Commerce. And if you go there now, if you click on that Go There button, if you scroll down, you notice section 75 is not there yet. So they'll put that there when it becomes effective in May. So if you have any questions, just go read it. I'll just give you a quick summary of what went into this legislation today. But for more details, just go there. We'll send the slides out, and you can go in here to look at section 75 and just read it yourself. So yeah, Stacey, just go back to our presentation. Thank you. So next slide. It only pertains, the Ombudsman Office will only interpret information having to do with the state statute. And they'll interpret Title 57, again, going back to that same le.utah.gov code section, into Chapter 8 and Chapter 8A. And I put links there. We don't need to look at those now, but they'll be part of the slides that you will get. So there's no interpretation of your governing documents. So if you as an association or as a member of your association calls and they want to say, you know, we have a particular rule and they're not enforcing this rule, or they're enforcing it too firmly, they're simply going to say, that's not our job. We don't interpret rules. And if there's something in your CC&Rs that they're not enforcing or they're not following, again, the Ombudsman Office won't help you there. They'll simply say, according to those 2 chapters of code, whether or not your association is in compliance with the state statute. So again, as I mentioned, lot owners and associations may submit these. There is a $150 fee every time you submit a request. So you need to be serious about what you're submitting here. I think that will help prevent some of the individuals who just like to complain just for complaint's sake. They'll have to pay $150 for every complaint, and that'll stop a lot of that. So it has to be something fairly serious. Can't be filed later than 1 year after the incident you're complaining. And you must use up all your other resources. You must have talked to your HOA board. You must have, you know, if you have an attorney, you've talked to them first. Opposing parties, you need to notify the, you know, you're complaining about your HOA. You need to let them know that you're going to make a complaint, or if you're an HOA, that you're making a complaint about a specific member. So first of all, talk to each other. That's the most important thing to do. Talk to your board, talk to your other members of your association, and make sure you go through that step first before we use the Ombudsman Office. Next slide. So it establishes, again, the Office of the Homeowners Association, talks about, again, in this Chapter 75, the duties, jurisdictions, functions, requires the Ombudsman to issue an advisory opinion, provides the circumstances under which the advisory opinion is admissible in a subsequent proceeding. And then one of the good things here is that if this office ombudsman doesn't work out, or we don't get any calls, or the calls that they do get can't really be addressed, in 2030, the legislature will have to review this ombudsman, this whole chapter, and determine, okay, how effective has it been? That's one of the concessions we got from our representative, Walter, on that is, yeah, we'll put a repeal date in there. So next slide. So again, they'll issue a written advisory opinion, and they're generally not admissible in evidence in court, although I think there may be some circumstances where they are. If the complaint is fraudulent, the person who makes the complaint, they're either not allowed to put in more complaints or file more complaints, or they may impose, if it's egregious, they may file a $1,000 fine to that person who files the fraudulent complaint. And the vexatious filers, there's some rules about individuals who keep filing and really never go anywhere. And then court costs, attorneys. So again, we didn't want people to use this just to be complainers. This has to be fairly serious, and they're willing to pay the $150 per incident. And then it's up to these attorneys. Now be aware that this will take effect actually in June when they get the funding, but the funding is going to be done by an additional fee that will be assessed in every property. And I'm not sure if others here are talking about that, but I'll just quickly mention it. Based upon discussion with the Department of Commerce, it'll be a $95 fee for every community association in Utah, and you will have to register every year. Previously, it was $37, and you only registered when you had a change. That will now require you to file every year and pay the $95 per year per association. So that will go into effect probably this year when you register. So they'll have to start building those funds up to pay for this office. So we'll see what happens this year. My gut feel is it'll be at least the first of the year before the office is really fully staffed and up and going. But I could be wrong on that. Again, it's not there now, and it won't be there until they get their director hired and staff hired and trained. So, Stacy, is that all my slides?
It is. Thank
That's
you,
it for me. So if
Um,
you have any questions, put them into the chat, and I'll turn time back to Quinn.
Yeah, we did have one question that came through that I'll address. You know, I do need to say one thing just so everybody knows Bruce's background a little bit. He is a former member of the State House of Representatives. So I feel that we're very blessed, I guess, to have Bruce as a member of our Legislative Action Committee, because as we've worked on these things, especially this bill on the ombudsman issue, Bruce has been great to go up to the Capitol to meet with different people, to testify when needed. And I think his contacts he has from the time he was in the legislature has been beneficial as well, because he already has that relationship, and it automatically brings a level of credibility as we're talking to them.
Thank you, Quinn.
Yeah, well, you're great, Bruce. And about, you know, as we talk about the ombudsman and this bill 217, if you go through the history, it didn't get passed until it was the fifth substitute. And I think probably almost all of those substitutes we were involved with. And as the members of LAC were going and talking about some of the issues, really trying to reduce the impact of some of the, you could say, the negative provisions that we would view, and working with them to improve it. Obviously, they have their own opinion of what they want in there, but this bill is really one that we put a lot of time in working with the legislators to address some of these issues, and in our opinion, make it better for community associations, while also balancing the rights and the interest of owners. And you know, one of the big ones that we put in here, and Tyler, you can comment it because I know you had more discussions on this. It's those safeguards that we were able to get into the ombudsman provision to help prevent owners from weaponizing the ombudsman's office, and really requiring them to exhaust their remedies before they approach the ombudsman's office, and then also putting in the limit of after filing multiple times and the ombudsman's office rejecting the request because it's outside the scope of their duties, then they're vexatious filers and they can be locked out from future filing unless they go and appeal and go through that process. So we were able to keep the rights for people to submit a claim, but then also put in some protections to prevent just, you know, them weaponizing it, using it as harassment or as leverage in any, you know, kind of resolution efforts. So, okay, moving on, we'll go to Tyler Lamar. It's talking about use restrictions. Tyler, as you start, if you do want to make any comments there on the ombudsman, feel free to do that before you go into your other provisions.
Awesome. Thanks, guys. Great recap. Thank you, Bruce and Quinn. I thought that was a great description of what we're up against with the ombudsman's office. So we can jump right in here, and then you guys can help monitor the chats. We've got a couple questions that have come in. Okay. First of all, we have new rules on HOA rules. So there's new restrictions on the type of rules. That's good. You can go forward with it, Stacy. We've got new restrictions on the type of rules that an HOA can adopt. So first, we're going to address flags. You guys are probably familiar that the last few years we've had some new legislation on political signage, and a lot of questions arose surrounding flags. Well, we now have some clarity on it. You might not love the new legislation, but we have more clarity on what restrictions can be placed on flags. And this slide summarizes those areas where flags can be restricted. We can restrict time, place, and manner. Nothing's changed there. That's very same for political signage. And we can limit content, but only in these specific ways. We can only limit the content or substance of a sign if it's obscene, profane, or commercial. Now, I understand that each of those terms has a definition, that it might be subjective, and we're going to need to rely on kind of a reasonable person standard and some context. But these are at least some tools to be able to limit certain messages that are obscene, profane, or commercial. So the next slide is going to depict certain flags that I believe could be prohibited, that we've probably seen flying in our communities here in Utah. So these are the flags on the left are political messages, but they have a profane aspect of them to them. So I think those could be prohibited if your HOA chose to do so. You're not required to prohibit profane signage, but some HOAs choose to and would want to do that. On the right side, we have flags that are a commercial message. These are the type of things that an HOA could prohibit. If somebody wanted to advertise a salon or a boutique or something like that in the neighborhood, you could prohibit a political sign, even though it's a flag. Okay, so the next slide is intended to depict flags that we could not prohibit. Black Lives Matter, pride flags of any sort, LGBTQ flags, a Confederate flag. We did have one community with a swastika flag hanging in a window. I raised that to the representative that pushed this bill. And initially it was under 327 and it got folded into HB 217. I raised that specific issue. I showed an image of a swastika in a community in Lehigh expressing the concern for some of these divisive messages that are sent. And he said, yeah, I think that that's probably going to be permitted. So that is not intended to be precluded by an HOA. You have the American flag under distress. That's been a controversial one as well. I think that that would be permitted because it's not profane, obscene, or commercial. Utes and BYU, I think that's probably permitted. It's not blatantly commercial. You can make an argument that it's commercial. But, you know, I think sports flags, affiliations to sports teams would probably not be under the umbrella of what we could prohibit. Again, the representative that pushed this bill specifically said he wanted to fly the flag of his school. So I think that's the intent, is to be able to allow those type of flags.
So Tyler, if I can interject, there was a
Please.
question as you're talking about this. And
Let's go, Brandon. Is that obscene or profane? My
so,
take is no. I mean, I get what's behind that, and I understand how the "Let's Go Brandon" phrase evolved, and you have to kind of know that background to know that there's a history of some profanity behind that from that NASCAR event. But I don't think that message in and of itself would be something that an HOA could restrict and call it profane. But there's an argument there, maybe some context. Maybe you could persuade a court to uphold a fine for that. I think my takeaway is HOAs are being asked to take hands off flags a little bit, that we should not be regulating content of flags except in the most clear-cut circumstances where it might have contained some obscenity, which is rare. I can't even think of an obscene flag that's out there in the community, but profanity is more common. Commercial is certainly common. Okay, let's go ahead, Quinn.
I would agree that, you know, the "Let's Go Brandon," I don't think we can restrict that because it is context.
Yeah.
As you dig into it, we know what that means. But with these specific examples, right? I mean, we also know there's some of those, and the background and context, you know, the swastika, the Confederate flag. I mean, those are very offensive to some people.
Absolutely.
We can't restrict. I mean, the bill sponsor said no, like they're permitted to fly those. So I think something like a "Let's Go Brandon," it's going to be permitted. It doesn't have, you know, specific profanity on that. And
Yeah.
so, I don't think that we would be able to. Now, maybe the Utes and BYU one, depending on where you fall, that could be profanity.
Yeah,
You may
there you
be
go.
able to restrict that. I don't know.
I mean, offensive is definitely not one of the categories that allows us to restrict. And the questions come in, does this apply to both rules and CC&R provisions? Okay. The statute on its face only applies to rules, but we've got this problematic provision under the section of both the Condo Act and the Community Association Act that says that CC&Rs cannot contradict the rules as it pertains to this topic. So although the text of the code does not specifically address CC&R provisions, we have this catch-all provision that says only with limited exceptions, when it's addressed under this rulemaking authority, that section of the code, your CC&Rs cannot contradict that. So beware of that. Even though it's under the rulemaking section, be cautious about trying to fall back to your CC&R provisions. And this has been controversial. It's something the LAC has tried to address. It's gotten a little bit out of hand, in my opinion, with the legislation that we've been seeing. And we should make an effort in an upcoming session to kind of get back to what should appropriately be kept in CC&Rs versus what should be addressed by rules. Okay. The next slide is intended to depict some circumstances and have some discussion around time, place, and manner. Okay. So time, place, and manner restrictions. A time restriction, let's say we're dealing with holiday flags or holiday signage. It would be perfectly appropriate to have a time limit leading up to a holiday, maybe after a holiday, to put up your flags and your signage related to that holiday. Those restrictions must be reasonable, however. So we can't use a time restriction to essentially, and in essence, prohibit a flag. So it would be, in my opinion, completely unreasonable to say you may place your flag for 2 hours on the 30th of July, but no other time beyond that. That would be unreasonable. But if you feel like your community can adopt a reasonable time constraint, that is still permissible. You can have like a manner restriction, which may relate to a size. I've got a photo here of a flag that's draped across the entire house. Even the US Flag Act and the Utah Flag Act allows us to adopt reasonable size restrictions for the flying of flags. We've got some other depictions here of nice flag poles or a pole that's attached to the eave of the home. You may have a concern about attaching a flag to the exterior of the home. So you might be able to restrict that and confine it just to flag poles. Notably, in the Condo Act, the only area where an owner has the right to fly a flag is in the window of a condo. Okay. But in a planned unit development, in a community association under the Community Association Act, it is not limited to just windows. It would be front yards, even if the HOA maintains control and maintenance of that front yard area. Okay. And other places on their home that they control. So keep that in mind as you consider reasonable time, place, and manner restrictions.
Hey, Tyler, as you're talking about the American flag, I do have, another question.
Yeah.
In one of the prior slides, we had the upside down American flag.
Yeah.
And I think this is one of the interesting situations because we have this amendment going into place stating that we can't restrict flags, but then there's another provision in the statute that does say the association can't prohibit the display of the United States flag in these areas. But if the display complies with the federal code of how you fly the flag, right?
Yeah.
So, and so that is interesting because it's saying, hey, well, there's the federal law, and we've adopted that. So if you're flying it in compliance with that, it's fine. If you're not, then can we restrict it? Does this amendment, kind of override that, saying, well, no, you can't. So
I think the amendment broadens an owner's right to fly a flag, even if it would not comply with the Flag Act. So personally, I think this expands an owner's right to fly a flag beyond the Flag Act because it's not obscene, commercial, or profane, even if it's upside down. Another question came in from Natasha. Could we prevent the flying of flag where affixing the pole or affixing the flag would create damage to an HOA controlled building component? Absolutely. That's the perfect example of a manner restriction or a place restriction on flying of a flag. So that's a good example of where you'd be able to jump in and exercise some rulemaking authority. Okay. So there's a lot we could talk about on flags. We could probably spend the whole time exploring the nuances of flags, but we got a lot of material to cover. So we're going to jump on now to parking on public streets. This one's pretty simple. There were some cases throughout the country that suggested that an HOA had authority to regulate public street parking under their contract of the CC&Rs. Well, that's been clarified in Utah. It's also been clarified in Arizona. We cannot prohibit parking on a public street. So this applies to any type of vehicle, okay? So if it's an RV, a trailer, anything like that, we have to rely on city code to be able to enforce public street parking. We cannot rely upon HOA rules or HOA covenants to address public street parking any longer. Okay. Next topic is driveway parking.
Sorry, hey Tyler, we've got, Brett has his hand raised for a question. Brett, did you mean to do that? I should be able to talk to Brett to ask your question.
Let's see if we can ask him to unmute.
Yeah.
I think Stacy may have to allow him to comment.
Yeah. If not, you can put your question in the chat there, Brett.
You just answered my question about the stucco. Thank you.
Love it.
Okay.
Awesome.
Great.
Okay. We had other questions come in about time restrictions on flags during elections. Yeah, absolutely. You could do that if it's political statements. You could have reasonable election timeframes. Okay, what about parking that obstructs the flow of traffic? On a public street, you have to go through the municipality, the county, whatever authorities over that public street. You'd have to rely on the county or city authority to deal with traffic flow. Maybe cops, maybe the fire department or the fire marshal, but the HOA has to be hands off on public streets. We can still regulate our private streets, just not public streets.
There's another question, which it's good clarification because it is in the statute. What about requiring them to park in the garage before?
Okay, that's this next slide. So now we're going to talk about driveway parking. And although this is included in the code as, we'll go back one more slide. Although this is addressed in the code in a negative way, so we'll jump back 2 now. It's all good. Oh, we're only going forward. Hey, we're going to get done with this presentation so fast.
I'm so sorry. I don't know
it's
how
all
to go
good.
back. It's
Up
Will the
arrow.
down button or back button get you back, or
it's not.
Yeah, should use the up arrow.
I know, I did, but it's not.
even if
Just
we just,
very progressive, Tyler. We don't go backwards.
well, so
I'm
even
so
if we
sorry.
escape back out and then we can navigate and then go back into present mode. So if you push escape, will it get you out of there?
No. We're still going for it. I don't know how to do this. Oh,
So while we're looking to do that, in driveways, we can no longer restrict driveway parking. However, we are allowed to require that a vehicle be parked in a garage that's appurtenant to the driveway first before being parked in the driveway. So although this is framed as a restriction in the code, it is an example of a provision where the HOA is now expressly allowed by rule to create a hierarchy of preference about where you park. So we can require the owners park in the garage first before parking in the driveway. We can also now by rule expressly restrict parking of motorhomes and RV trailers and commercial vehicles in driveways. Now, as a caution, commercial vehicle is defined in the code, probably not like you think. It's not a truck with a plumbing sign or a Domino's pizza delivery ornament on the top. Instead, it's like a big commercial truck. It's a very large truck that's contemplated in the code that you can prohibit. So hopefully that addresses that. We can have some authority prohibiting parking. Thank you, Stacy. Well done. In the driveways for RV trailers, motorhomes, inoperable, and commercial vehicles. And we can require that people park in the garage first before parking in the driveway. Perfect. Okay, let's go on to the next one.
Let's try.
It's going to go backwards now. All right. Basketball standards. The legislator that adopted this one was very passionate about basketball. Okay. His HOA did not allow basketball hoops in his driveway. And he wanted to say, and Arizona's done this too, by the way, they wanted to say basketball hoops for everyone, regardless of the circumstances. Well, basketball standards actually cause conflict sometimes in HOAs. For example, if you have a very small driveway and every time you shoot the ball, it goes into the next neighbor's drive or hits their car, or, you know, you've got Dennis the Menace types and their grouchy neighbors that don't want the kids with balls in their neighborhood. So we at least have some limited authority to regulate basketball hoops. Basketball hoops have to be in a driveway or private area that is maintained and owned by the owner that abuts a public street. The reasoning behind that is private streets are often much narrower or may not even have a sidewalk that could create like a safety buffer where vehicles are coming by fast. So if it's abutting a private street, you don't have a blanket right. HOA can still regulate it. But if the driveway abuts a public street and the owner owns it and controls the maintenance of it, and it's properly installed and maintained, the HOA can no longer regulate basketball hoops. Okay, we've had some questions come in.
Tyler, just one comment on that. It was
Yes.
brought up by one of our meetings we had just the other day with some of our CAI associates, is with the ombudsman office, now that we've got basketball standards, and you're going to be talking about gardens. So now basketball standards can be regulated by the ombudsman office.
That's
So if you have
true.
a basketball standard and it's not being displayed properly, the ombudsman office will have to make a ruling on that, and the same with your next one, which is going to be gardens and parking. So what we're doing is turning a lot of what used to be the local rule making by your HOA is now being passed up to the state, to the ombudsman office. So
Yep.
interesting is what happens.
That's
Tyler,
right. Okay, we've got a lot of
There's
questions
a-
that have come in.
Yep.
I'm gonna go rapid fire on some of these. We cannot do an end around on public street parking by having a catch-all provision. In my opinion, we cannot do an end around by having a catch-all provision that allows us to adopt rules to enforce the city code, because the code is absolutely express that we cannot have any enforcement action on public streets. So I think that one is addressed. Garage conversions. We all know that there's a right for owners to create internal accessory dwelling units, which might be in a garage. If it's been converted from a garage to an ADU or something like that, and that was previously approved, then we can no longer express preference that they park in that garage, which isn't a garage anymore. It's now an ADU. So I think that takes that off the table, but it would have to show that the conversion was previously and properly approved. We have questions about the time limits for parking in the garage. 1 minute, 1 hour, 1 day. There is a separate provision that says rules must be reasonable. So if you're doing a 1 minute restriction, to me, absolutely unreasonable, right? It's up to each HOA to work with their council and their manager to adopt reasonable regulations about transition periods of loading, unloading, staying in the garage, staying in the driveway. I would beg everyone on this call, please be reasonable, because what we heard all throughout this session were stories of unreasonable conduct by board members and managers, which lead to these laws that further restrict our ability. So I think it is important that we all try to police ourselves in this industry and adopt reasonable regulations about basketball hoops, parking, and things like this. A question about portable hoops. Well, the statute does say properly maintained and installed. We've had some debate in our office whether a portable hoop is installed or assembled, right? I think there is a reasonable argument to make that you could restrict a portable hoop, but I'm sure lawyers will have a great time debating and arguing these topics for years to come. So we don't know for sure the answer to that. Single loop road, is that private? We can't tell just by those facts as to whether your road would be private. We would need to look to the plat map, which would designate whether your road is public or private. Other questions? Yes, the commercial vehicle is defined by weight limits in the code. A Mercedes Sprinter van,
And I included the definition of motorhome down
Perfect.
below, Tyler. So,
awesome. We'll get that one covered through that. Awesome.
well, you may want to expand on it because it talks about it's a self-propelled, for.
If it's primarily designed for travel, then I think it does meet the motorhome definition. But some Sprinter vans are not. Some are more commuter based or utility based, or so I think it depends on the nature of it. There's like the Winnebago version of the Sprinter van. I think that clearly meets the motorhome definition. So okay, there's definitely going to be some gray area on these topics, guys.
Yeah,
Okay.
great attorney response, right? It depends.
It depends. All right. We also cannot prohibit vegetable gardens. The way this bill was initially drafted, we could not prohibit vegetable gardens anywhere in the yard. Okay. It was gonna be permissible to have corn on every surface of your landscaped area. Gratefully, we were able to negotiate for a substitute that limits it in a more reasonable way to rear yard areas. We can still regulate the height, water use, fertilizer use, weed maintenance, and invasive and unlawful species. So, Gwen, I think your cannabis garden is still probably not permitted. So sorry about that. Okay. Moving right along. Let's talk about preferred vendor lists. You probably all encountered HOAs that want to create a list of vendors for various tasks, whether it's rebuilding your deck or working on your sprinklers or pesticides or lawn fertilizers. This is no longer permissible. We cannot require that an owner use a vendor from a preferred or required vendor list. We cannot even require that vendor be licensed, except if the work that they're doing requires licensure by law. So a good way to think about this, if it requires a building permit, it probably requires licensure by law, and you could require that they be licensed through Department of Professional Licensing. But if it's just a handyman thing where you don't have to have specific licensure, we cannot require a preferred vendor or that they be licensed and insured before allowing them to do the work. Okay. Let's talk real quick about architectural approvals on the next slide. There was a concern that some HOAs were just denying ACC or architectural control or architectural review request without providing sufficient reasoning to the owners. So we now have to provide a written notice that states the specific governing document provision which justifies the denial, and we have to describe what aspect of the plan submission does not conform to the association's rules. So the days of just being able to say denied are gone. We have to give a reason and give specific citation to the applicable provisions. Okay. Question came in. Is garden exception for non-common areas only? Yes. Vegetable gardens only apply to areas that are owned and maintained by the unit owner, and that section is not in the Condo Act at all, nor is the basketball section in the Condo Act. So basketball hoops, vegetable gardens, limited only to a non-condo PUD. Okay. Question came in, what about a property manager for a nightly rental? This is also something that our lawyers have debated and wondered about. I don't know if a preferred property manager vendor is permissible any longer under this statute. I certainly don't believe that was the intent of the statute, but I think the plain language could be applied to suggest that a preferred vendor or a nightly rental manager is no longer permissible. But I will let you work with your specific counsel on some of those issues. And that's a very good question. Could shake up the industry quite a bit. Okay. The question came in, we're a voluntary property association. We're not registered as an HOA through the HOA registry. We do have our own CC&Rs. Does this apply to us? That is again going to depend on what your CC&Rs say. So if you are registered on the HOA registry, they definitely do apply because that creates an obligation to follow the Community Association Act or the Condo Act. If you are a post 2004 community, even if your CC&Rs do not mention it, it probably still applies to you, but we could get with you specifically to address that question. Any lawyer in our industry would be able to help you answer that question. Okay, we've got some other questions. What if the city required that nothing be placed that results in water intrusion into the soil? That is the type of water restriction that we could regulate for vegetable gardens. If there's hydrocollapsible or hydro-expansive soils and they're very sensitive, that is something we could address. I know at Daybreak, there's also sensitive regulations about planting food in their soil because the contaminations from mine tailings and things like that. We can address those type of things still for height, safety, water restrictions, things like that.
Well, Tyler, on those where there's tailings or something similar at a Superfund site, there's usually going to be EPA reports that are specific to that area. That's, you know, the federal provision is going to override, you know, what we're looking at here. So.
Yep, agreed. Logan has asked, does the ARC approval apply to developer-controlled communities? Yes, there is no exception to a developer-controlled community. They have to be able to deny and point to whichever section justifies that denial. Okay. I might have to come back here and address some of these in the chat when we pass it off to the other, because we've got a lot of questions coming in. We will share the slides. That's possible, right? That was a question that came in. Absolutely, we'll make the slides available so that you guys can review them. Okay, 2 more slides for me, and then we'll pass the baton. The next one deals with what I think is a very confusing label of an association transfer fee. Okay, I wish they would have called this something like an initial setup fee for a new owner or something like that, because the transfer fee comes with a lot of baggage. In most cases in Utah, transfer fees are prohibited. This was a tool for developers to profit from the communities they created by taking a little bit of money for every home that sells into perpetuity. And in most cases, those are now banned in Utah. There are a few that arguably are grandfathered, but in most cases, transfer fees are banned. As you know, we can do reinvestment fees, which allow us to collect a similar fee, but the money has to stay in the HOA and it has to be used for an association purpose. We now have a new creation. It's called an association transfer fee. It's not a reinvestment fee. It can only be used to cover administrative costs of the transfer. And I think to help people understand what this is, these are commonly charged, but they've arguably been illegal until now. So this is the fee that goes to a management company to cover their administrative cost to help a new owner get set up in that HOA. This code now allows and recognizes what we call an association transfer fee, but the amount that you charge must be included in a fee schedule, which will be addressed. I think Quinn or Lauren or one of you going to address that one.
Yeah, I've got it.
You've got it. Okay. So beware that if you want to charge this kind of fee, it has to meet the definition as included in the code. It can only be used to cover administrative costs, and it must be disclosed in a transparent way in a fee schedule before you implement that fee. Okay. All right. Last one. This one's kind of confusing. I'm not going to spend a lot of time on it. You're probably familiar with prior legislation that says CC&Rs only require a 67% approval, even if your governing documents had a higher threshold listed in them. So if your CC&Rs say 75%, in most cases, you can amend it with only 67%. Well, this legislation addresses it on the other end. So to illustrate the problem, we heard stories of certain communities in southern Utah that were allowed to amend their governing documents with a very small minority, in some cases by a board vote alone, and in some cases by a majority of whoever showed up at a meeting. So the concern that's being addressed by this is that a small majority of owners could change the CC&Rs for everyone in the community. So now, and this isn't going to apply to hardly any of you, the minimum threshold to amend the CC&Rs is a majority of a quorum of at least 51%. So you have to have a quorum of at least 51% of your community participate, and then a majority of them would have to approve it. So at the bottom threshold, 26% of the community could amend the CC&Rs if 51% of the community participates. Again, I don't think hardly any CC&Rs will permit this, but if you do have a rare set of CC&Rs that allow a smaller percentage than that to amend, this now increases the threshold to amend the CC&Rs. Okay, one question that came in about the reinvestment fee. A reinvestment fee is kept in HOA funds for HOA improvements. This can be charged at sale of unit as a percentage of the sale. Yes, so long as you have an appropriate reinvestment fee covenant or provision in your CC&Rs that allows you to do it, and it's the amount that's allowed by the code, then yes, you can collect a reinvestment fee upon and as a result of a transfer of a lot. Now, certain things are exempt by code, and we don't have enough time to get into the background and recap that. So if you have questions, feel free to reach out. Okay, follow-up question. If we have 20% of the community that ever is involved in quorum is based off the 20% that showed to the meeting, correct? I'm not sure I totally understand your question, but at a minimum, in most cases, you're going to need 67% to amend your CC&Rs. But if your docs allow a very low threshold, at a minimum, you're going to need to get 26% of the community to approve it after 51% have participated in that vote to amend.
So to clarify on
Yeah.
that, I'm interpreting it as if our quorum requirement is 20% of the owners,
It's increased by this legislation.
Yeah, we now have to, you may meet your quorum requirements at 20, but this statute is stating you need to be higher than 20%. You have to have, that higher 51% of the owners to be participating.
But only for CC&R amendments. I don't want people to panic that this affects quorum for any other purpose. Right. So this has zero impact on quorum for an annual meeting or for elections or anything else. It's only for CC&R amendments.
Yep.
Okay.
So you got to, it'd have to be that higher quorum requirement and then half at 51% of the owners.
Yep.
So
okay.
Right. It's limited to only the amendments.
On the association transfer fee, the question is, does it matter if it's billed to the HOA or to the owner? And the answer to that is, this is addressing a fee that's being charged to the owner. If you're charging it to the HOA, that's just some agreement that you have with the HOA to charge them for you. And that's always been allowed. So a management company can agree to their own fees with an HOA for handling a new setup. This addresses when you want to charge a new owner a fee because of a closing. That's all that this addresses. Okay. All right, Quinn, I will jump back in and make sure we didn't miss anybody and answer those questions that haven't been addressed, but that's it for my section.
Okay, thank you, Tyler. So.
All right, I'm going to just touch briefly on rental restrictions, some changes that came into effect or will be coming into effect in a few weeks here. So one change is going to be largely administrative, probably mostly for the management committees, and it is simply that an owner of a rental unit can designate a primary contact who you need to send all the HOA communications and notices to. And when they send you that designation of their primary contact, you need to send them a written notice that you've updated the records to indicate that this person is the primary contact for this rental unit. The other change is with the short-term leasing and what we can do in rules. So our leasing restrictions should generally be in the declaration, but you can set by rule a minimum lease term of not more than 6 months. So up to 6 months, you can restrict by rule but you can't make a longer lease term requirement in your rules. And then the part I know you're all interested in is the other fee, because we love fees this year, right? The $200 a year administrative fee that was passed recently last year that can cover some of those administrative expenses that you incur when you have rental units in a project. It wasn't clear when that was applicable, what kind of administrative expenses, what we were supposed to show in exchange for that. And I'm going to tell you, it's not any clearer. So first, we'll tell you that those unit residents that were previously accepted from the restrictions are also accepted from the $200 fee. So if you've got a close family member living in your unit, you're renting out to them, no $200 fee can be assessed for that unit. A unit owner who was renting before the regulation, before any leasing restriction, their grandfather, no $200 fee, et cetera, et cetera. You'll go forward, Stacy. This is going to be probably the biggest procedural change for rentals. Before a community can start charging that $200 per unit fee, rental unit fee, they've got to have a management committee meeting. They need to send a written notice to all the owners 15 days before the meeting, regardless of what your bylaws say, regardless of what any of your notice provisions say. It's got to be 15 days prior to the meeting. You've got to allow some comment and discussion from the owners, and you've got to explain what the new administrative expenses are that are going to be covered by this fee, and explain why they're necessary, what has changed that is causing the requirement for this fee to be applicable. And after that, you just need a majority of the management committee to approve the fee. Now, you'll notice we highlighted new administrative expenses. We don't know what that means. I know Tyler had some pretty lengthy discussions with the bill sponsor about this. Like, this is really confusing. Do you mean expenses that we didn't have before, or just new with regard to this rental unit because it wasn't rented before? I don't know that we can tell you any of those answers. But after the management committee approves the administrative fee, within 30 days, you've got to send a notice to all of the unit owners who are renting their units and explain again what expenses are being covered by the administrative fee and the catalyst for the administrative fee. Now, an owner can contest a fee in writing if the HOA fails to satisfy those requirements in that 30-day notice. And the HOA will then be forced to waive the fee for that unit. So dot your I's, cross your T's. And if you have any insights on what new administrative fees are, I'm sure we'd love to hear them. And I'm done. Take it away, Quinn.
Okay, thank you. So I know we're short, and the good news is I can get through mine rather quickly. So I am talking about the fees and records requests. And so we have covered some of these. Bruce touched on this one about the ombudsman. And so what you've got is everybody's updating their HOA registry. That's been in effect for many years. But you only had to update it when there was a change in your board members or manager, and you had 90 days. That has now changed. The amount will go up. We don't know what it is. If you see in the slide, we even have $90 and then $95. So we're hearing different things, and we don't know what it'll be. They initially thought it was going to be lower, then they realized they had calculated the number of HOAs in the state. And instead of paying it periodically, maybe every couple of years as you change board members, it's now annually. The intent of the bill sponsors, requiring this is to fund the ombudsman's program. And so it's on the back of associations of how that's going to be funded. If you want to speak out on, these fees, there is a hearing on May 7th at the Heber Wells building. And that's so downtown. And so
That is at 3 o'clock. They moved it to 3
Oh, they
o'clock.
moved it to 3. Okay, 3 o'clock. It was at 1, they moved it back. So, thanks, Bruce, to clarify that. In this, it stays the same. If you fail to register properly, it means you can't enforce your liens for people who are delinquent. Okay, go on, Stacy. The next one. So we've kind of touched on this a little bit with one of the questions of, well, if the statute is stating you can't do this in the rules, what about if it's in your declaration? And I, Tyler addressed that very well. Generally, if it's in your declaration, you can rely on it, but there are certain provisions given the statute that would even override that. So we would need to look at certain situations. Don't just rely on a blanket, well, our CC&Rs override that. But when it comes to late fees, it does talk about it's the greater of 10% of the assessment or $50. And so you do see in a lot of CC&Rs where it just says, hey, if for non-payment, you can pay a late fee. And then boards, you would set that late fee in your rules. So this is one to be aware of. I was talking to somebody just yesterday and they said, well, we have one annual assessment in January. And then if you don't pay, we charge $50 every month. And I don't think you can do that. I think it's the one-time $50. And then if they don't pay, then that's where you charge the interest. And the statute allows for up to a 1.5% per month interest. So you may have it below that, but you can't go above 1.5. So the other thing that is important is the statute now requires every association to adopt a fee schedule before charging these fees. And so that would be your late fees, interest, the reinvestment fee, the association transfer fee amount. I would include in there any fines that you may charge due to violations. And the question is even, well, what about our assessment amount? My recommendation is you put that in there into this fee schedule. I think the bill sponsor's intent with this, coming from a real estate or realtor background, is not me, but the bill sponsor, is when we are representing somebody, either the seller or the buyer, we want to be able to take a page or a 2-page document and hand it to the purchasers that says, here's the fees you will incur by moving in. So if you kind of think about that of what the HOA may charge, put it on the fee schedule. And you will have to update that periodically. If you change assessments, if you then charge a special assessment, you're going to want to make those changes and get it out to your owners. Okay, next one, Stacy. So the next one is on providing documents. So owners already had a right to request records. What we have here is some clarification on specific records that would be produced. I think many of those were already addressed with the meeting minutes and then accounting or financial records, but now they're spelled out more specifically. It also talks about the before, if you're doing the work and gathering them, you weren't able to charge, or you could charge certain amounts if you're making copies. If it's sent electronically, either by email directly to them or on a website, you don't charge. If you are doing hard copies, you can charge up to $20 per hour for the person that's doing that work. That's up from $15. And it talks about delivered within 2 weeks. If you fail to comply, it was $500 that they could seek from you. Now it's $1,000. Keep in mind that the statute still requires them to send a demand for non-compliance and give you 10 days to come into compliance. So that is still that's still in effect. And many of you already get these records requests. If it's clear that it falls into one of the specific documents that they get, just comply. If it falls into some gray area, you think it exceeds the scope of the statute, I would say talk to your counsel so that they can look at that, because there is even the question of, do they get everything, or is there some limitations? So talk to your counsel about those specific situations. Go ahead and go on, Stacy. So as we're coming up on the end of the hour, I mean, we can have some additional questions here for a few minutes, but I just want to wrap it up by saying again, thank you to all those members of LAC who have supported this. Thank you for everybody who's joined today for your interest. And we put in a lot of time. Nobody on LAC gets paid. It's all volunteer, just as our efforts to help the industry. We do pay a lobbyist, which is important because of their contacts and be able to work with those legislators more full time. And so we do need, some financial support to continue to advocate for community associations. So you can go ahead and donate. Use that QR code. Again, if you get the slides, then you can do that. Many communities build it into the budget. They may do $1 per door in their community, once a year and donate that. Others may do a little bit higher. Some are just individuals, but every little bit helps so that we can better advocate for the interests of our industry. And especially, it is important because what we're seeing, and especially we saw it this year, like the basketball standard and some of those, Tyler, you can comment, it's there's one person who has a bad experience because they want the basketball standard. And so then they go and change the law for everybody and put some of those things in. And so again, one bad experience, or I should say negative experience, has now developed into law that's binding on everybody. So, okay, we are at the time, but if there are a few questions, go ahead and ask those. I know, Tyler, hopefully you were looking at some of these because there are a lot of questions.
Yep,
Hey,
I've
Quinn?
answered most of them. Yeah.
Okay.
Yeah, one question came up. Are we just going to send these slides out to everybody registered, Stacy? I'm assuming.
Yeah.
Stacy.
You're on mute.
Yeah, I can, or you can email me and I can just send them to you directly.
Will you put your email in the chat there, Stacy? Just so everybody's
Yes,
got.
I will.
So,
Hey,
okay,
Quinn, we just had a question. I know we're out of time about
Yeah.
Corporate Transparency Act. I think we'll just say it's still in effect, but the president has issued an order to say don't enforce it.
right. Yeah, for domestic entities. I don't think there's any HOAs that are foreign, but yes.
Greg asked about where do we register with the Ombudsman's office? We don't need to. We just do the HOA registry. So Google Utah HOA registry, and that's where you register.
Right. Okay, so there's another question about the records request, about the list of owners or lot owners. Does that fall within the statute for the $1,000 for noncompliance? Yes, because they are entitled to receive a list of the HOA members. You can limit that to their names and address. You don't have to give phone numbers or emails. But if they ask for that and they ask for it properly by complying with the statutory requirements or procedure, you do have to provide it. If you don't, and they follow the process of demanding noncompliance, and you still don't provide it, they can bring an action and get $1,000 or their actual damages and attorney's fees.
But can I just last thing, please donate if you can, guys. We all donate our time and we donate our money as well. But if you can help, it really helps us balance this and to have representatives that are more willing to listen to us and have great support up at the Capitol. And then lastly, please stay tuned for our blog posts because there's a couple bills that we did not address at all in this. They're less urgent, but still very important topics. So watch for those blog posts because it's got some great info about new legislation that we just didn't have time to cover.
And if you know other HOAs who are particularly non-managed, they still need to know this information. So we have a lot of great managers that are here today. But if you happen to know others who are in non-managed HOA, this also applies to them and they need to know this. So pass it on as appropriate.
Okay, great. Well, again, thank you, everybody, for those who participated, those who came to listen, and for your time. And until next time. So, okay, thank you.